So, my Lord, my humble submission is that the only authority which can make rules regulating the practice and procedure of the court is the Honorable Supreme Court, and not the Parliament, sir. This is my humble submission. And for that purpose, I'll say that subject to the Constitution law does not mean that the Parliament can legislate. So subject to law, subject to Constitution, has it been interpreted in Imrana Tiwana's case, my Lord? It basically subject to means a restriction, sir. It is not an enabling provision. And subject to Constitution has been dealt with in the case of Imrana Tiwana, and I'll come to law after that. 2015 SCMR 1739 at page 1765. 2015 SCMR 1739 at page 1765, para 53. My Lord. The word subject to Constitution do not therefore make Article 137 for subservient to the provisions of the Constitution. All that these mean is that where the Constitution creates a specific bar to the exercise of such executive or legislative authority or provides a different manner for such exercise, then the authority must either not be exercised at all or exercised in such manner as the Constitution permits. It does not mean that provision prefaced with such words is a subordinate constitutional provision. It also cannot mean once the province has devolved certain powers on the local, its legislative executive authority is faced by the local government. So basically it is a restrictive thing and says that it's a bar, not a enabling provision for legislation. Then what is the meaning of subject to law? My humble submission is that subject to law does not mean, implies the implementation rather than grant of power, number one. It doesn't imply, it implies implementation rather than grant of power. If rule-making power is made subject to legislation, sir, then the rule-making power of Supreme Court will become functus officio. Constitutional grant of rule-making power is construed as a continuing power, sir. So there cannot be any limitations on that, or constitutional power given that. It is not an enabling provision. Subject cannot mean subject to legislation, sir. If subject law is interpreted as Supreme Court's rule-making power as subject to, then that would be a grave violation of independence and separation of powers doctrine, sir. Subject law means substantive law. Subject to law means substantive law as distinguished from pleading and practice. Substantive law includes much more than legislation. It includes common law. Subject to law means power as to practice must not invade the field of substantive law. So there has to be something existing. It cannot invade the field of substantive law. But it does not give them the power to legislate, sir. And, sir, with your Lordship's kind permission, I have prepared
what you're saying is that the Parliament cannot make rules nor legislate regarding the rules. And all the Parliament can do is subsequent legislation नहीं हो सकती. ये जो existing law था उसके दायरे कार में रहते हुए और कानून
आप rules नहीं बना सकते.
दायरे कार में रहते हुए power in any event vests in the Supreme Court.
Supreme Court exclusively, sir, because the word used is not just rule making; it is regulate. That we can by rule regulate the practice.
I'll read the provision.
Yes, my lord.
Let's reframe the whole provision.
My lord.
It says, now let's read it like this.
My lord.
The Supreme Court may make rules regulating the practice and procedure of the court.
Yes, my lord.
So are you saying that Supreme Court had to be advised about the Constitution, had to be advised about the law, because it would make rules which will be completely in violation of the Constitution and the law? So it would have been much simpler drafting to start it with the Supreme Court. Rules regulating practice and procedure of the court. Your contention is that a high body, as a constitutional body, as the Supreme Court, had to be reminded that there is a constitution in existence. Don't violate it. That's a very strange proposition.
No.
You are putting redundancy to the words subject to the constitution and law, because what you are saying can equally be said by using these words.
My lord, with the utmost respect, my lord.
Well, if you read it
जवाब
in
दे
the way,
नहीं, let's hear the council. जी
Yes.
please सुन लेते हैं council को.
I'm also reading it the same way. The Supreme Court may make rules and regulating the practice and procedure of the court,
My lord.
subject to the Constitution and the law.
My lord, my
Which
humble submission.
which means Supreme Court can make rules,
Yes.
whatever rule it wants to make,
Ji.
but it can't go beyond
Beyond the Constitution or any law which already exists.
So there
तो
is
वो
a
मेरा
limitation.
सवाल अपनी जगह ठहरा. हजूर आप जवाब तो दे
Ji,
दें.
my lord, with the utmost respect, I'm not reading it as.
Utmost respect को छोड़िए, सिर्फ जवाब दे
अच्छा
दीजिए.
सर, आपके साथ.
जरा वक्त की
But I'm
कमी
just-
है.
जी, I know, my lord. I'm just saying that subject to law. Subject means some kind of
मैं आपसे
restriction.
कुछ और मैंने आपसे
Sir, आपका
अच्छा आप
defendant
फिर से
see-
आप देखें जो मैंने सवाल है उसका तो आप जवाब
सर,
नहीं
मैं आ
दे
तो
रहे.
जाऊं उसमें.
नहीं, आप आएंगे तो अगर दिन निकल जाए. मैंने कहा अगर ये हम लफ्ज काट दें सब्जेक्ट टू द
जी.
कॉन्स्टिट्यूशन एंड द लॉ, फर्क क्या पड़ेगा फिर?
जी.
ये इसका सवाल का जवाब दे
सर,
दीजिए.
फर्क नहीं पड़ेगा, लेकिन पॉइंट इज
नहीं पड़ेगा ना.
नहीं, लेकिन इशू
Thank you.
नहीं, इशू ये
चलिए next point.
नहीं सर, पहले अभी सुन तो लें, मैं कंप्लीट तो कर लूं सर आपकी इजाजत से. अगर फिर भी कोई लॉ आप रूल नहीं बना सकेंगे which violates any provision of the constitution.
Is this something to be taught to the Supreme Court?
No sir, but I'm humbly submitting subject to law does not mean the parliament can legislate. That's humble submission. Subject to, क्योंकि जहाँ parliament, जहाँ constitution power देता है parliament को बना दे, specific words are used.
चलें खैर,
जी.
अब पता नहीं आप redundancy is
I'm not assuming it is, I'm
1,
just
2,
saying.
3, 4, 5, 6 words of the constitution we can delete as rendered meaningless.
Sir, I'm humbly
I'm reading
submitting
it like that if I accept your
Sir,
contention.
subject to only means, my humble submission is that subject to only means that there's some kind of a restricting, because the constitutional power, which is a continuing power, is being given to the Supreme
Noted.
Court.
Next point.
Ji. The point is that the words used in the if Parliament, if Constitution is giving power to the to make any law, it specifically used certain words in the Constitution. If my Lord kindly sees 154(5), Article 154(5). Next page. My Lord, until Majlis Shura Parliament makes provision by law in this behalf, the Council may make its rules of procedure. These are the words. Then Article 6.3, my Lord, if my Lord kindly sees Article 6.3. Article
6.3 or 63?
6.3. Article 6, subclause 3. I see. 6, Article 6. Majlis shall by law. Article 6, my Lord. Yeah.
जी पढ़ लिया.
J. Majlis shall by law provide punishment of persons found guilty of high treason. Then my Lord will kindly see 151(2).